Well, the US has introduced new guidelines for H-1B visa holders who have been terminated from their jobs, providing options beyond the 60-day grace period. But what does this mean for H-1B visa holders? Well, a non-immigrant worker's employment ends, either voluntarily or involuntarily. They typically may take one of the following actions, if eligible, to remain in a period of authorized stay in the United States. Either file for a change of non-immigrant status, or file an adjustment of status application, or the third option is file an application for compelling circumstances under which workers may qualify for a one-year employment authorization document. The fourth option being filing an application to become a beneficiary of a non-frivolous petition to change employer. But failure to take action within the grace period may require leaving the country, and if the worker takes no action within the grace period, they, as well as their dependents, may then need to depart the United States within 60 days or when their authorized validity period ends, whichever is shorter. This is what the US government says. Soundarya Balasubramani joins us from San Francisco for further clarity on these changes. Soundarya, thank you so much for making time for us. Take us through how these new guidelines regarding the H-1B visa differ to the ones that were in place before.
There is really no difference to the new guidelines. I think USCIS just wanted to remind people that, hey, if you got laid off in the last 6 months, then don't forget that we've published guidelines on what are your options once you got terminated.
Right, but Soundarya, major corporations like Google, Tesla, they've announced layoffs. How do the new guidelines affect those that have been terminated or have a fear of being terminated? And was job termination an existing fear for these workers?
Yes, it is absolutely a fear. I've spoken to hundreds of students and immigrants in the last few months, and it's something that everyone mentioned. I will say that the guidelines that USCIS has published is a very long document with a lot of FAQs. There's a few highlights that I just want to mention for people. So number one, USCIS does let you transfer from whatever visa you're on, say an H-1B to a B1 or a B2 tourist visa, so that you can switch to that and then keep interviewing on that visa, which will give you another 6 months to stay in the US. And then hopefully if you get a job, then you can transition back to an H-1B or another visa. So USCIS confirmed sometime last year that you can interview on a tourist visa, and that is okay. Secondly, if let's say that you have a compelling circumstance, they have something called a compelling circumstance EAD for those who have an approved immigrant petition. So someone who has an approved I-140 petition who has a compelling circumstance, which they haven't clearly defined what that means, but a lot of people have applied for that. So that is also another option that you could pursue if you have an I-140 approved. And finally, if nothing works and you have to leave the country, then by law, your employer is supposed to pay for the transportation cost to kind of offboard you from the country and back to your home country. So it's worth asking your employer that if there's no other option for you.
Thanks so much, Soundarya, as always, for joining us with that quick comment.